Hello, this is Matt on the Moon Lambo channel. Got a few topics of discussion. We might be seeing some fireworks this Tuesday, June 7th. As most of you know at this point, there's going to be a hearing in court, in person. The SEC and Ripple and Judge Knepper all getting together to have a killer time. And what's going to be discussed? Well, one of the big things that's on the table right now is the SEC's attorney-client privilege assertion, which is completely bogus. And I'll just say this before we get into the meat of this video. Attorney Jeremy Hogan points out how the June 7th SEC/Ripple court appearance could absolutely wreck the SEC lawsuit. Also, Attorney Deaton, on a different topic, he talks about the hunt for those who may have profited from insider info about Hinman's free speech, including those who may have shorted XRP, by the way. And also, former SEC Chair Jay Clayton. Well, if you didn't have a low enough opinion of him already, what I'm going to share with you will help. I learned something new about him today. It turns out that he actually went on the attack against whistleblowers, effectively, while he was still chair at the SEC. What a terrible creature. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So here, what's on your screen right here is a little cutout from a memo from Perkins Coie. Now, this is the law firm that created a memo, which is basically a framework for how securities law would apply to crypto. So this is dated March 26, 2018. So this is what Hinman used. It's 49 pages. Hinman used this as a framework for his speech, effectively. Of course, just his opinion, mind you. But what he had to say in the ETH-free pass. But here again, March 26, 2018. And Attorney Hogan shared this little excerpt from it. And I'm not going to read it because it's not necessary. If you want to hit pause, take a look at this, the excerpt that he highlighted. Attorney Hogan, he talks about it in a sufficient manner to cover what's on your screen right now, so I don't want to take the extra time. But if you want to, feel free to hit pause here. But here's what Attorney Jeremy Hogan had to say about this memo, which then led to a question about what's going to happen Tuesday, June 7th. Going to see some fireworks in the court? Well, anyway, here's what Hogan said. The Perkins/Hinman speech is criticized for making up the requirement that when a utility tokens network is decentralized, the token ceases to be a security, but at least it provided a logical framework for analysis. That the SEC has completely abandoned it is telling. So folks, why did the SEC abandon this? Think about it. You'll see as I go through the rest of Attorney Hogan's comments. Think about what Bill Hinman said on June 14th, 2018, when he gave the Ethereum free pass speech. He basically made the case for why Ethereum is not a security, which would mean if you apply the logic that he went through to any other security, if that's going to be the framework of the SEC, and that's how the market responded, even if it's just his personal opinion, well, apply that to any other cryptocurrency, and you can figure out what they're going to sue and what they're not. If they're consistent, which they're not, but they have abandoned that. Might it be because there are different people in charge of the SEC right now and it was never an official policy anyway? He thinks that might have had something to do with it. But anyway, Attorney Hogan continues. The Perkins memo does have a logic to it. Number one, a sale of a share of stock will always be a security. So I'll just pause to note, that's something I've actually been saying on and off for years. The whole time I've been running this channel, I bring it up from time to time. Because look, when you're talking about an actual, like if you're just buying a stock, there is no utility there. You don't use it for stuff. You don't use it to buy stuff. It's purely an investment. That's what a stock is, right? Whereas if you're purchasing a cryptocurrency, it could be for the purposes of investment, but depending on the cryptocurrency, it could be offering additional utility. That's certainly the case with XRP, functionally used in enterprise-grade software. So yes, it can be a vehicle for investment, no denying that, but also other stuff. So cryptocurrencies are superior to just stocks in that sense. And then number two, and as Jeremy Hogan continues here, it's number two, a sale of a utility token is a security and becomes not a security when the ledger is decentralized, so that there is no reliance on the efforts of others, per the Howey test. This is the beginning of a logical framework. It's how Hinman then manipulated it that is problematic. Yeah, so I'll pause to state there. In terms of how Hinman manipulated it, I'm not going to put words in Attorney Hogan's mouth, but I'll tell you, it seems clear to me that he was talking about selective enforcement. He cited the earliest sales of Ethereum, which he has to have known amounted to like $18 million, if memory serves anyway. Because you're talking about the first ICO in history, the first initial coin offering. There wasn't a functional platform. And he said something along the lines of, well, setting aside the sales of the earlier stage. So I'm like, whoa. So you're manipulating a framework so that you can set that aside so that you can give Ethereum a free pass for whatever your reason is. And I think it's monetary. I think that there's likely something to that. So yeah, pure manipulation in play. And then Attorney Hogan said, but the SEC quickly discarded this framework. It's as if it went too far, would have taken too much of the crypto space out of the SEC's grasp, and that couldn't be allowed. Exactly. So why did they stop with this framework? With what Billy Boy Hinman had to say? Because if something's sufficiently decentralized, the SEC's not in charge of it, and they can't have that. They don't want to have language anywhere that would indicate that if a cryptocurrency is sufficiently decentralized and thus there is no common enterprise, they don't want that anywhere, because then they can't sue everyone into oblivion. And then somebody named Darth Trader on Twitter responded to Mr. Hogan and said, how are you expecting the upcoming hearing to play out? And Attorney Hogan said, I don't see how the SEC is going to walk the fine line that they are trying. More problematic for them is if she asks, so referencing the judge, if she asks for the rest of the emails to review, and that will include the one they don't want her to see. Ouch. Yeah, so there's a couple things at play here that are big. As I already cited in the intro of the video, there's the attorney-client privilege assertion, which is completely bogus. Probably not going to go so well for the SEC on that one. I would not be surprised if that comes up. But, as Attorney Hogan cited here, more problematic for them is if she asks for the rest of the emails to review. So he's talking about all the emails associated with the Bill Hinman Ethereum Free Pass speech. And of course, then there's the drafts of the speech itself. Because mind you, to this point, the judge has only reviewed in person a handful of those emails. So we're all speculating that there's something here in these emails that the SEC really doesn't want us to see, potentially exculpatory. So just ruin the case for the SEC, resulting probably in a willingness to come back to the table for settlement. There's got to be something there. There's a reason we're all speculating this, including Attorney John Deaton. He thinks so too. There's got to be something in there, right? Okay, so what might happen? Well, this is why it could wreck the SEC's case on Tuesday. If she demands that they turn over to her, not even to Ripple, just to her, the rest of the emails for in-person review, well, then the naughty one in there, that says probably something about XRP, something that ruins their case, she will see that for sure. So whatever was handed over, we don't know that it would have included that. And also, it's worth pointing out, there may be more than one instance within all these emails that would destroy the case. There could be more. So there's got to be at least one, or else they wouldn't be fighting so hard. But there could be multiples. So if all this gets handed over, game over, SEC. Sorry, but you lose. Take your ball and go home. And then there was this. Somebody named Bully McGuire was asking what the odds were for settlement, and what percentage do you, like in terms of opportunity for settlement, what percentage would you put on that? And Attorney Hogan said, 95% is a statistical number. So he's talking about there's a 95% of cases actually settle. But then he said, but this case has all the hallmarks of one that could go all the way. The only thing is, if the SEC is smart, they'd back off on Ripple and get their case authority with a case with better facts. End quote. So, very poignant, that's for sure. Like, why? My gosh. See, this whole thing was rushed because Jay Clayton was out the door. If not for the administration change, I don't know that there would have been a lawsuit right then or ever necessarily. I don't think they had all their ducks in a row, despite planning for a couple years at least, or research and investigating all this. Despite that, this wasn't the best case to go after because they're wrong on the facts. So pick an easy one, set precedent that you can point to. That would have made more sense for the SEC, but that's not what they did. And so in that sense, maybe this will be like a happy thing. Once it's all said and done, something good will come from it. It'll never be good that, it harmed XRP holders, but something good still can come from it, obviously. Grinds my gears, folks. Now take a look at this. Here's a video clip that was shared by my fellow XRP YouTuber DAI. And I actually went ahead and transcribed this. It was on CNBC. This was June 7th, 2018. So this is 7 days before the Ethereum free pass speech. And there, I got it right here. Yeah, there it is. So the host said the following, referencing Jay Clayton. He said, the chairman declined to say whether Ether or Ripple were actually securities. But is it fair to say that this is ultimately going to be litigated in the courts? And then an SEC employee, well, he's not anymore, but at the time he was an SEC employee, Brett Redfern said the following, because he knew it was coming down the pike. He said, it's unclear to me whether or not that's going to be litigated. I don't want to speak about any specific products, and I do believe there will be statements on at least one of those products forthcoming in the future about providing some more guidance on that. End quote. So, folks, what do you think he was talking about there? He was talking about the Bill Hinman free pass speech, obviously. He was directly asked about well, as it was worded by the host, Ether and Ripple, so he meant XRP. And then he says, yeah, there's going to be something forthcoming. Well, how about that? And so Attorney Deaton retweeted that this afternoon, and he wrote the following. Great find, DAI, 3 things. Number 1, Redfern received a draft. Number 2, he's one of the officials who resigned and left the SEC after supporting the lawsuit, i.e. mass exodus, that Grunfest mentioned in his letter to the SEC. And number 3, we know as of June 7th, 2018, Redfern knew Ethereum was getting a free pass. And then there was another clip here, and John Deaton shared it, and he says, this below is the next day after Redfern says soon we will hear from the SEC regarding one of the tokens, Ethereum or XRP. And a quote from this, as highlighted by DAI, is as follows. And this is from Joe Lubin, co-founder of Ethereum. He said, we certainly need bodies like the SEC to scare many projects straight. It's so laughable. They had the first ever ICO. That's a freaking securities. Oh my God. Unregistered security sale. Unquestionably. And then he's got the gall to say, well, he knew he had the free pass, obviously. He's in the inside here. He's highly confident. He doesn't deserve it. It shouldn't have happened, but it did. And so then Attorney Deaton writes, this is after a meeting with Hinman on June 8th, 2018. So again, now we're 6 days before the Ethereum free pass speech. And then Deaton says, he knew he was getting the free pass. Who bought Ethereum between March 28th, 2018 and June 14th, 2018? Did they have inside knowledge? Did anyone who purchased Ether between those dates also short XRP? If so, we know he/she knew. So that's what our community, that's one of the things anyway that our community has been hunting for, is a smoking gun on that front now. That would be big. Now, luckily, these are public blockchains, so the information's there. You just have to piece it all together, which is the difficult part. Now, as far as Jay Clayton, I'm going to be brief on this. Here's a headline from, what was the date on this thing? September 18th, 2018. It's a little bit after the Ethereum free pass speech. Not that that particularly matters, but it was back in that era, just pointing that out. And the key piece I wanted to highlight is as follows. Under existing rules, whistleblowers who provide original information that helps the SEC collect at least $1 million in a penalty can receive 10% to 30% of that money. There is no cap on awards. Most of the awards given out since 2012, when the SEC issued its first payment, have been less than $2 million, but a few have been far higher, including $39 million that went to a whistleblower earlier this month. So that's what the piece says. By the way, that's quite a windfall for these people. That's incentive to take the risk and say, hey, SEC, go look at so-and-so organization. Now, because look, there is risk associated with this for whistleblowers. Understand, there's serious career risk, but people will be more likely to shed light on nefarious deals and shady intent if they know that they're going to be, or it's likely that they're going to be taken care of here, right, monetarily. So what did Jay Clayton do? Well, he wanted to take that away. He's more like, oh, thanks for being a whistleblower. Here's a gift card to Starbucks. Something really smart. I'm being a little facetious, but I wanted to take all of that incentive away because he wanted more money for the SEC. He wants to keep it. But the thing is, in doing that, you're not going to catch some of the worst guys soon enough because whistleblowers won't be as likely to come out. That's just a matter-of-fact type of thing. It's quite obvious. And so here you can see this ended up passing. Here's a headline from December 7th, 2020, as he was on his way out the door. Jay Clayton making sure next SEC chair doesn't have to pay as much to whistleblowers as he has. This greedy SOB, this is a terrible human here. Did he do anything that was good at the SEC? Please point to it. He had to have done something, right? He had to, seriously, he had to have done something that was good for society, right? Because most of what I see, it's just completely awful. It really steams my vegetables. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.